Hello and welcome to the final part of the PIH training on the Violence Against Women Reauthorization Act of 2013. Again, I'm Ryan Jones and I continue to be joined by my colleague Miranda Stern. In this part, we'll discuss home ownership with continued assistance, owners in the Housing Choice Voucher Program, including the Model Owner Notification of Rights and Obligations that appears in Appendix 2, assistance under more than one housing program, fair housing and non-discrimination, and the first appendix item on discretionary policies and procedures. As a reminder, the material discussed in this training may be found in Notice PIH 2017-8. The VAWA final rule introduces two new protections under the Homeownership Voucher Program. First, an exception was created to the prohibition of PHAs offering continued tenant-based assistance for occupancy of a new unit so long as the family members owns any title or other interest in the prior home. Second, an exception was created to the flexibility of PHAs have to establish policies that prohibit more than one move by the family during any one-year period. So let's take a look at the protections in greater detail. First, the exception to the prohibition of PHAs offering continued tenant-based assistance for occupancy of a new unit so long as a family member owns any title or interest in the prior home. When a family or a member of the family is or has been a victim of domestic violence, dating violence, sexual assault, or stalking, and the move is needed to protect the health or safety of the family or family member, or any family member has been the victim of sexual assault that occurred on the premise during the 90-day calendar period preceding the family's request to move, such family or family member may be assisted with continued tenant-based assistance even if such family or family member owns any title or other interest in the prior home. The second exception to the flexibility PHAs have to establish policies to prohibit more than one move by the family during any one-year period. If a PHA has such a policy of limiting the number of moves within a one-year period, they must make an exception to the number of moves for when the family or a member of the family is or has been a victim of domestic violence, dating violence, sexual assault, or stalking, and the move is needed to protect the health or safety of the family or family member, or any family member has been the victim of sexual assault that occurred on the premise during the 90 calendar day period preceding the family's request to move. The remainder of the section in this notice on homeownership goes on to cover some operational matters for implementing these provisions. First, PHAs must not continue homeownership assistance to a participant after commencing tenant-based rental assistance. Per the program regulations, a family may not receive the benefit of tenant-based assistance while receiving the benefit of other Section 8 assistance. If the family moves out of the home, the PHA may not continue homeownership assistance after the month when the family moves out. Commencement of tenant-based rental assistance results in the participant no longer being a participant in the homeownership program. The participant's sale of the home or the participant's potential loss of the home due to foreclosure must not affect the participant's continued participation in the program. The PHA's obligation to terminate voucher homeownership assistance upon mortgage foreclosure only applies while the participant is still in the homeownership program. It does not apply to termination of tenant-based rental assistance for a participant who is no longer in the homeownership program. Lastly, PHAs must not recapture voucher homeownership assistance on the sale or refinancing of a home purchased with assistance under homeownership option. Section 21 of the notice includes three sections on owners in the Housing Choice Voucher Program: notification to owners, mandatory owner obligations under VAWA, and lease revisions resulting from domestic violence, dating violence, sexual assault, or stalking. Let's start with notification to owners. First, let me say that the VAWA final rule did not include a specific requirement that PHAs notify owners of the VAWA requirements. Having said that, educating owners on their rights and responsibilities under VAWA may lead to greater compliance, resulting in increased victim safety. HUD encourages PHAs to identify opportunities to provide notice and/or training to owners participating in the Housing Choice Voucher Program of their rights and obligations under VAWA. PHAs are encouraged to attach the PHA's emergency transfer plan and Form HUD 5382 to any notice they provide to owners, or to otherwise make these documents readily available, such as they are made readily available to participants. To ease the burden on PHAs that may decide to issue a notice to owners, HUD created a model owner notification of rights and obligations. This model notice may be found in Appendix 2. Here's a screenshot of the first page of the model owner notification of rights and obligations. Just as providing the notice to owners is entirely optional, the use of this template is entirely optional. PHAs that choose to issue notice to owners are in the position to determine what is appropriate for the community. Again, PHAs may also choose not to provide notice, instead relying on the VAWA information contained in the HAP contract. I should note that at the time of this recording, not all the VAWA final rule protections are included in the HAP contract or tenancy addendum, so the notification of rights might help cover that gap. Like the other model documents, this document provides areas where the PHA inputs its name or other information. The notice explains owner rights and obligations, provides applicable regulations, and discusses denial of tenancy, eviction, documentation moves, lease bifurcation, and confidentiality. The notice also provides an area where the PHA may include contact information both for the contact at the PHA, should the owner need to discuss VAWA, and for organizations that may assist the owner or that the owner may refer the victim. Mandatory owner obligations under VAWA, there are 3. Tenancy, screening, and eviction. An owner must not deny the tenancy an applicant or evict a tenant on the basis or as a direct result of the fact that the applicant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking, if the applicant or tenant otherwise qualifies for admission, assistance, participation, or occupancy. The second column, certification or documentation. Owners are not required to ask for documentation when an individual presents a claim for VAWA protections. If the owner chooses to request an individual to document their claim of domestic violence, dating violence, sexual assault, or stalking, the owner must make such a request in writing. The individual may satisfy this request by providing any one of the document types listed under 24 CFR 5.2007B1. Exceptions to this provision in the case of conflicting documentation, of course. Lastly, victim confidentiality. Information submitted to an owner, including the fact that an individual is a victim of domestic violence, dating violence, sexual assault, or stalking, must be made in confidence. The final part in this section is on lease revisions resulting from domestic violence, dating violence, sexual assault, or stalking. PHAs may encourage owners to allow tenants out of the lease if a family member is or has been a victim of domestic violence, dating violence, sexual assault, or stalking, and the family needs to move to protect the health or safety of the victim. The PHA may not terminate assistance if the family moves out of the unit with or without prior notification in violation of the lease in order to protect the health or safety of the victim, as the victim reasonably believed they were imminently threatened by harm from further violence if they remained in the dwelling unit. Similarly, if the family moves out of the assisted unit in violation of the lease in order to protect the health or safety of a family member who is or has been the victim of domestic violence, dating violence, sexual assault, or stalking, and who reasonably believed they were imminently threatened by harm from further violence if they remained in the dwelling unit and has otherwise complied with all other obligations under the Housing Choice Voucher Program, the family may receive a voucher from the PHA and move. Any family member that has been the victim of sexual assault that occurred on the premise during the 90-day calendar period preceding the family's move or request to move is not required to believe that they were threatened with imminent harm from further violence if they remained in the dwelling unit. State or local law may have protections for victims beyond those in the VAWA or HUD regulations. Nothing in VAWA should be construed to supersede any provision of any federal, state, or local law providing greater protection than VAWA for victims of domestic violence, dating violence, sexual assault, or stalking. As such, owners and jurisdictions that provide greater protections for victims must grant those protections for victims. When the entire family moves from the contract unit for any reason, including to protect the health or safety of the family member that is or has been the victim of domestic violence, dating violence, sexual assault, or stalking, the HAP contract terminates automatically. The PHA must not pay HAP to the owner of the previously occupied unit once the family moves out. If the perpetrator remains in the unit, the PHA continues to pay the owner until the PHA terminates the perpetrator from the Housing Choice Voucher program. If the HAP contract terminates for any reason, the lease terminates automatically. If a family moves out of property at any time during the month, the owner may keep the housing assistance payment for the month when the family moves out of the unit. In the event the PHA executes a new HAP contract with a new owner after the victim moves out of the original unit to protect his or her health or safety, the PHA must not disclose the victim's new address or any other information collected on the new HAP contract to the original owner, as the information collected in the HAP contract is protected by the Privacy Act. I'll turn it over now to Miranda to talk about assistance under a more than one covered housing provider.
Thanks, Ryan. When assistance is provided under more than one covered housing program, and there is a conflict between VAWA protections or remedies under those programs, other individuals seeking the VAWA protections or remedies may choose the protections or remedies under any or all of those programs, as long as the protections or remedies would be feasible and permissible under the program statutes. Where housing is covered under multiple HUD programs, the responsible housing provider under each program will provide the required VAWA Notice of Occupancy Rights and Certification form, and tenants may request emergency transfers or lease bifurcation under any applicable program unless prohibited from doing so because of statutory constraints. For example, Home Investment Partnership Program or home funds were used for the rehabilitation of a development that also has 20% of its units under PVV. In this scenario, both the PHA and owner are covered housing providers under their respective programs. The PHA must follow the requirements of VAWA under PVV, and the owner must follow the requirements of VAWA under PVV and home. A victim seeking VAWA protections, for example, an emergency transfer, may seek an emergency transfer from under either or both covered housing programs. It should be noted that housing providers must comply with all applicable fair housing and civil rights laws in the implementation of VAWA requirements. For example, housing providers must provide reasonable accommodations for individuals with disabilities, such as a reasonable accommodation to any requirement that the emergency transfer request be in writing, and must help certain individuals put their request in writing, if requested, or where the need for such assistance is obvious. Individuals with disabilities may request a reasonable accommodation at any time to any program rules, policies, or practices that may be necessary. Housing providers must meet accessibility requirements when making emergency and other transfers, which may include making physical modifications to dwelling units and common use areas. Housing providers must ensure that communications and materials provided in a manner that is effective for persons with hearing, visual, and other communication-related disabilities. Provide appropriate auxiliary aids and services necessary to ensure effective communication, including ensuring that information is provided in appropriate, accessible formats as needed, such as Braille, audio, large type assistive listening devices, and sign language interpreters, and take reasonable steps to ensure meaningful access to their programs and activities to limited English proficiency individuals. To close out this training, let's spend a few minutes walking through the discretionary policies and procedures chart included as Appendix 1 in the VAWA notice, We included this chart with the intent of highlighting the various areas where PHAs have discretion in how they implement VAWA, or where VAWA requires the PHAs establish policies but does not prescribe the specific policy. Let's start with the first item in the list. How and where will Form HUD 5382 be made available? For example, will the form be posted on the PHA's website? And where else will it be made available? Or how would someone ask for the form? Under certification or documentation, a big policy decision is whether the PHA will ask for documentation or allow verbal certification. Will this be on a case-by-case basis, or will there be a PHA-wide policy? Further, there are specific circumstances where the PHA will provide greater time to provide documentation, or will the PHA leave broader discretion with the staff members responsible for this activity? Under both the 5-year and annual plan subject lines is the question of what activities the PHA will provide that aren't required by HUD, but will help the PHA achieve its goals. Moving on, in either the HCV or public housing program, will the PHA establish a waiting list preference, and what does this preference look like? In the case of providing the VAWA Notice of Occupancy Rights, if there will be no recertification or lease renewal prior to the deadline to provide the notice, how will the PHA provide the notice? Let's continue to skip around and on to the next slide. While the confidentiality requirements of VAWA are clear, how is this operationalized at the PHA would be determined locally and will depend on staff roles, system and documentation requirements, and other elements that are PHA specific. Among the things a PHA will want to do is define who will be the point of contact, who will have access to the information, and how is this information secured. For example, does the PHA still use paper files for certain actions, and how are these kept confidential? For other PHAs, how does VAWA fit within their vendor software, and how is access secured for only those that require access to this information? The PHA's emergency transfer plan is another area where the PHA has a lot of discretion in setting up how the requirements are operationalized at the local level. This includes policy definitions, like defining immediately available and reasonable time to determining how internal and external emergency transfers are operationalized, and what outreach activities the PHA will take. The key to success of VAWA is the creation of partnerships. Again, VAWA doesn't require partnerships, but best practices indicate that they positively contribute to the provision of VAWA protections, from identifying organizations that can help victims in crisis to educating the PHA staff. Based on local and state laws, will the PHA offer lease bifurcation in the case of VAWA? Also, what will the PHA do in cases of conflicting claims of abuse? Will the PHA issue assistance to both victims? Finally, with regards to notification of owners for PHAs administering the HCV program, for example, will the PHAs be providing a notice to owners who should an owner contact if they have questions about VAWA and a voucher holder? With that, we conclude PIH's training on VAWA 2013. Thank you so much for your time and attention in viewing this training. And please, let us know through your local field office if we can be of assistance.